first meeting of the Special Committee to consider miscellaneous communication number 1003 pursuant to House Rule 14, Speaker Suzuki by memorandum dated February...
Excuse me. I'm not hearing you.
Oh, okay.
There's too much noise.
Well... How's that? Can you hear that?
Yes.
All right. I'll start again. Good afternoon, everyone. Welcome to the first meeting of the Special Committee to consider miscellaneous communication number 1003, pursuant to House Rule 14, Speaker Suzuki by memorandum dated February 4, 2015, appointed this committee to address a challenge to Speaker Emeritus Say's qualifications to serve as representative of the 20th District. Speaker appointed me, Carl Rhodes, chair of the committee, and named Vice Speaker John Mizuno, Majority Leader Scott Psyche, Majority Floor Leader Cindy Evans, Assistant Majority Whip Ken Ito, and Minority Leader Beth Fukumoto Chang as members. The February 4, 2015 memorandum states the rules under which this committee will operate. The memorandum can be accessed online from the hearing notice for this meeting, or staff can provide you a copy over on this side. Rule 4 of the memo grants me the discretion to hold this hearing in order to allow the petitioners or their counsel to make their case and for Speaker Emeritus or his counsel to make his. Each side will have a total of 20 minutes to make their presentations. The petitioners will go first, followed by questions from members of the committee. Once the questioning is completed, Speaker Emeritus Say or his attorney will have a total of 20 minutes to make his case. Questions from the committee will follow. A court reporter will be transcribing today's proceedings, as you've probably already noticed. This will ensure that an accurate record of the hearing will be available. It also means that if you're answering a question, please actually say yes or no instead of nodding your head, and please only one person talk at a time so she can accurately take down the proceedings. After the presentations have been made and questions answered, the committee will adjourn to consider the information we gathered today, to assess the written submissions of the parties, and to further investigate any area the committee deems appropriate. Once these tasks have been completed, a draft report on the committee's recommendations will be prepared, and the committee will reconvene to discuss, possibly amend, and vote on the report. The report will be submitted to Speaker Suzuki and the full House of Representatives for their consideration. Rule 4 of Speaker Suzuki's memorandum requires that we investigate without delay. I am hopeful that we can complete our work within 10 to 14 days, but an important internal legislative deadline, first lateral, falls a week from today, which may delay the committee somewhat. The committee will post a notice for the next meeting at least 48 hours in advance as required by Rule 4 of Speaker Suzuki's memorandum. Of course, the public will be welcome to attend that meeting as well. For the presenters, there is a countdown clock over at this end of the table. And when the 20 minutes is up, if you could please stop at that point and be prepared to answer questions. So the petitioners, first, are there any questions from either of Mr. Kobayashi or Mr. Collins?
No questions.
No questions.
Okay. Mr. Collins for the petitioners goes first, and you have 20 minutes. Thank you.
Aloha and good afternoon, Mr. Chair and members of the Special Committee. I am Lance Collins, and I represent Ramona Hussey, Ka'inila Nicholson, Natalia Antonia Hussey-Burdick, Brent Dupuis, Marvin Heskett, and Joel Merchant, challenging the qualifications of Calvin K.Y. Say to be seated as the representative of the 20th District. The voters first lodged a petition for the writ of quo warranto before the First Circuit Court in 2012, challenging Mr. Say's authority to hold title to office in the 27th Legislature. The court dismissed the petition. The voters noted an appeal. The voters also lodged a petition with the Speaker of the House seeking this House to investigate the matter. The Speaker declined to take up the matter, indicating that it was for the courts and not the House. In the decision of Hussey v. Say 133 Hawaii, the Intermediate Court of Appeals reversed the Circuit Court and held that Circuit Courts have jurisdiction in quo warranto actions to try title to office. It subsequently denied Mr. Say's motion for reconsideration, whereby he argued the court lacked subject matter jurisdiction on the basis of Article 3, Section 12, which he argued conferred exclusive jurisdiction over the question of the rightfulness of one's title to office of representative to this House. Last year, the Circuit Court issued the writ of quo warranto. Subsequently, the House of Representatives of the 27th Legislature moved the Circuit Court to intervene in the proceedings on the basis that any decision other than dismissal would impair the House's interest under Article 3, Section 12. Motions to dismiss were filed. Last fall, the Circuit Court sustained the motions to dismiss on the ground that the House of Representatives and not the courts have exclusive jurisdiction to try title to office of representative. The court vacated the writ. The voters reiterated their petition to the Speaker of the House, seeking this House to investigate the matter. The Speaker again declined to do so, arguing that the House was not in session and that it would be unable to act without being called into special session. Last January, the voters again reiterated their petition to the Speaker of the House, seeking this House to investigate the matter. The matter was not referred to the Committee on Credentials, and the scope of the review of that committee did not include the information in the voters' petition. The Speaker appointed the special committee pursuant to Rule 4 of the memo of February 4th. This committee is charged to investigate the challenge without delay. Separately, Rule 4 gives the chairperson the discretion to allow the voters and Mr. Say an opportunity to present statements. Because Rule 5 requires that compelling evidence is necessary for the House to consider finding a member lacking the requisite qualifications to serve, it follows that the committee has a duty to investigate the matter to reasonably determine whether compelling evidence exists. This is so because only the committee is charged with investigating, and only the committee has the power to examine witnesses under oath and subpoena documents. If this committee follows the precedents of the U.S. House of Representatives, a certificate of election only establishes prima facie evidence that the person was elected by the people in a member's district, but it does not establish a fact or create a presumption that the person elected has been or continues to be a qualified voter of the district within which he or she was elected prior to filing nomination papers or continuing thereafter. Even if it did establish a presumption regarding qualifications, such a presumption is easily overcome by any contrary evidence. As Lord Acton noted once to the Bishop Mandel Creighton, "I cannot accept your canon that we are to judge Pope and King unlike other men, with a favorable presumption that they did no wrong. If there is any presumption, it is the other way against holders of power, increasing as the power increases. Historic responsibility has to make up for the want of legal responsibility. Power tends to corrupt, and absolute power corrupts absolutely. There is no worse heresy than that the office sanctifies the holder of it." Compelling evidence is evidence which demonstrates probable cause that Mr. Say is not qualified to serve in the House of Representatives. Quote, "Probable cause exists when the facts and circumstances within one's knowledge and of which one has reasonable trustworthy information are sufficient in themselves to warrant a person of reasonable caution to believe that an offense has been committed. This requires more than a mere suspicion, but less than a certainty." State v. Canberra 109, Hawaii. All of the evidence the voters have presented and note here today are available in the Archive of Government Records. As Michel Foucault noted, the archive is the border of time that surrounds our presence, which overhangs it and which indicates it in its otherness. It is that which, outside ourselves, delimits us. The available evidence shows that Mr. Say was born and raised in Pololo and until the early 1980s lived in Pololo. He got married and had children and moved in with his in-laws. This was both practical given his and his wife's work and also because family is important to Mr. Say, like all of us. For appearance sake, however, they bought a house near his childhood home and maintained it vacant for many years. In 1974, Mr. Say registered to vote at his childhood home and family's house at 1984 10th Avenue in Pololo. He ran for office in 1976 and was elected. His childhood home remained his legal address until the early 1980s when he married Mrs. Say. In 1983, the Says completed the purchase of a house at 1822 10th Avenue. This is the present address where Mr. Say claims residency. The Says also have 2 children. Mrs. Say taught out in the country, and Mr. Say was busy with his work and his duties as an office holder. The Says and their boys lived with Mrs. Say's family in Paoa at 2247 Star Road. Until high school, the boys attended schools local to Paoa and Pacific Heights. The Says took great care to have all regular correspondence, such as bills, sent to the 10th Avenue house, and have used that fact to support the proposition that they were legally domiciled at that address, and at least until 2006 for Mrs. Say. Mr. and Mrs. Say were registered to vote at the 10th Avenue house until 2006 when Mrs. Say transferred her registration to 2247 Star Road, joining their 2 adult children who continue to be registered to vote at that address. One oversight, or slip if you will, to this disciplined use of the 10th Avenue address was the address used by the city's Real Property Tax Division regarding the sending of notices of tax assessments and bills. Those notices for the 10th Avenue house were consistently sent to the Star Road home until voters in Palolo, St. Louis Heights, and Kaimuki began to challenge the propriety of Mr. Say's voter registration in the 20th House District through the voter registration challenge process. And it was not until 2010 until the address was changed to the 10th Avenue house. Public records show that the city clerk interviewed neighbors of the 10th Avenue house. One neighbor indicated he rarely saw Mr. Say physically present at the property. Another neighbor gave conflicting information. A retiree who had lived across the street from the 10th Avenue house since 1956 testified in 2006 and in 2010 that she had never seen the Says at the house and that no one had lived at the house for decades. In 2006, the Says admitted that at least from 1995, they had not lived at the 10th Avenue house, but rather at their home on Star Road. Mr. Say defended his total absence from the 10th Avenue house as what the clerk said, quote, due to extraordinary circumstances relating to the provision of health and living assistance for a member of his family, end quote. Mr. Say also claimed in 2006 that he spent most of his weekends at the 10th Avenue house. However, the city clerk and the Board of Registration both noted that such a claim was unlikely given that utility bills showed usage was extremely low. In 2010, Board of Water Supply billing records indicated that the Star Road home consumed, on average, 186 gallons of water per day, while the 10th Avenue house consumed 0 gallons of water per day, on average. Still, by 2010, neighbors continued to observe that the 10th Avenue house lacked any activity demonstrating anyone lived at the house. Mrs. Hirakawa, his across the street neighbor from the 10th Avenue house, continued to report that no one was living in the house. From 2012 until last year, Mr. Say continued to be absent from his house. However, it also appeared that one or more neighbors of Mr. Say began taking turns parking their cars in the 10th Avenue carport. Of the 2 cars registered to Mr. Say at the 10th Avenue address, neither of these motor vehicles had been observed to be parked at the 10th Avenue house. On February 22, 2013, Mr. Say was asked about his residency at a Palolo neighborhood board meeting. He told the audience that he considered the foregoing of rent income all of these years at his house at 10th Avenue to be a sacrifice he made as part of his duty as a good leader. Why would he forego rental income if he lived in that house? There is a general understanding in the community that Mr. Say does not live in Palolo, including those loyal childhood friends of his that live around his 10th Avenue house that have given conflicting information regarding his alleged presence at the house and now take turns parking their cars in his carport. Moreover, there has been a long-standing awareness in these very halls that Mr. Say lives at his wife's family home in Pauoa and not in Palolo. Even the Speaker of the House has said that everybody knew that Mr. Say's home was at 2247 Star Road. The Speaker stated that during his long friendship with Mr. Say, they would on occasion go drinking in the evening during session with other House leaders. After these Pauhana gatherings, the Speaker would take Mr. Say home to 2247 Star Road and never to 1822 10th Avenue. On one particular occasion, Mr. Say had had too much to drink or had come home too late, and Mrs. Say refused to let him in the house. After some time, the Speaker left Mr. Say on the step and went to his lodgings. These are the facts. As Gandhi noted, an error does not become truth by reason of multiplied propagation, nor does truth become error because nobody sees it. Truth stands even if there be no public support. It is self-sustained. Over the years, Mr. Say has sought to narrate these facts in such a way as to draw attention away from the core truth, which is that Mr. Say does not live at 1822 10th Avenue and likely never has. In the voter registration challenges, the main thrust of Mr. Say's argument regarding his legal domicile is that the law allows him a temporary leave to care for his ailing family members and to be with his wife, who was this ailing family member's primary caregiver until her death. At that time, he emphasized that he did not abandon 1822 10th Avenue as his legal residence because he, quote, intends to return. However, in 2009, the Hawaii Supreme Court in Dupree versus Haraga, 121 Hawaii, settled the question of whether intent alone is sufficient to bind someone to a legal residence. The court noted, if a person who has been living on the mainland packs up their belongings and ships them to Hawaii, flies to Honolulu and moves in with family members with the intent of making Hawaii their permanent home, they could be considered residents from the day they arrived. At the other extreme, consider a person who has a home in Los Angeles, flies to Honolulu, and registers to vote, and then returns to Los Angeles on the same day, all with the stated intent of making Honolulu his or her permanent residence. Recognizing such a person as a Honolulu resident would render the physical presence requirement in HRS 1113, Part 4, an absurdity. The only facts that demonstrate that Mr. Say has ever lived at 1822 10th Avenue is that he has used that address for his regular periodic mailings, such as bank statements and utility bills. While the content of those very same utility bills betrays the truth of the matter, there is no evidence of physical presence to support the long-held intent. As noted by the Supreme Court in Dupree, recognizing such a person as a resident would render the physical presence requirement an absurdity. The Honorable Representative from Wahiawa, a dear and loyal friend to Mr. Say, argued in a letter to the House last year, quote, even if one believed that what the petitioners argue was true, that Say was not a resident of the district in which he represents, because the general election of 2012 was the first after reapportionment, he may have been allowed to move without being disqualified from completing the remainder of his term, end quote. Mr. Say cannot avail of that alternative theory because Article 3, Section 6 of the Hawaii State Constitution only allows an incumbent representative to move to a new district without being disqualified from completing the remainder of the incumbent's term only if the move occurs prior to the primary election and the year after reapportionment. The legislature cannot vary the requirements of the Constitution except by proposing a constitutional amendment to the voters of this state. As Madison noted in the debates on the Federal Convention on the U.S. Constitution, the qualifications of electors and elected were fundamental articles in a Republican government and ought to be fixed by the Constitution. If the legislature could regulate those of either, it can by degrees subvert the Constitution. A republic may be converted into an aristocracy or oligarchy as well by limiting the number capable of being elected as the number authorized to elect. In all cases where the representative of the people will have a personal interest distinct from that of their constituents, there was the same reason for being jealous of them as there was for relying on them with full confidence when they had a common interest. This was one of the former cases. It was a power also which might be made subservient to the views of one faction against another. Qualifications founded on artificial distinctions may be devised by the stronger in order to keep out partisans of a weaker faction. It's in Volume 5, page 404 of the Debates on the Adoption of the Federal Constitution. It has been said that the legislature represents the public, allocates the values of society, and provides legitimacy for the government. Qualifications founded on artificial distinctions devised by the stronger in order to keep out partisans of a weaker faction do not represent the public, do not allocate the values of society, and do not provide legitimacy for the government or for this House. There is a natural tendency in organizations to demonstrate loyalty and extend the benefit of doubt to their own. But in so doing, the House will only endanger its own legitimacy and credibility in the process. If there be one among you who is not properly qualified to hold office, such a situation can only have a corrosive effect on the legitimacy and integrity of the House of Representatives as a whole. Obtaining a plurality of votes while unqualified to stand for office or hold title thereafter does not bolster any claim to legitimacy or right. It is impossible to determine voter intent where the apparent winning candidate obtained his place on the ballot cloaked in a legitimacy without right. Amy Cesare once noted, "A civilization that proves incapable of solving the problems it creates is a decadent civilization. A civilization that chooses to close its eyes to its most crucial problems is a sick civilization. And a civilization that plays fast and loose with its principles is a dying civilization." Thank you. I yield the balance of my time and I'm open to questions.
Thank you very much. Members, questions? I'm sorry, Representative Evans, did you have a... Go ahead. Oh, you're good. Go ahead, Representative Psyche.
Mr. Collins, do you agree that the petitioners have the burden of bringing evidence forward to the committee in order for us to make a determination on this?
Could you speak into the microphone more?
Okay, Mr. Collins, do you agree that the petitioners have the burden of submitting evidence to the committee for us to consider? The burden is on the petitioners.
Yes, the petitioners have the initial burden.
Okay. Is there? Are you planning on submitting supplemental evidence to this committee?
All of the evidence that I summarized in my summation was presented to the committee in the petition of January
16th. We have the petition. I was just wondering what the jurisdiction of this committee is in terms of the complaint, in terms of evaluating the complaint. The general election was on November 4th, 2014, and the majority of the evidence that you submitted predates the general election of 2014. Can this committee consider the evidence that predates the general election?
Well, it has to. The question of where someone's legal domicile is does not start the day after the general election. So the committee would have to consider all relevant evidence, regardless of probative, and relevant evidence, regardless of when it came into existence.
Okay, the legislature, at least the House, operates within bienniums, within 2-year cycles, from general election to general election. So, how is it that we can look at evidence that predates the current biennium that we are now in?
Well, again, if it's relevant and probative, when it was created is when the legislature comes into session into existence, when the term begins is irrelevant to whether or not the committee can consider evidence or not. Just because somebody is de facto a title holder and uses that as the basis to continue to establish erroneous legal residency doesn't suddenly mean that you can't review any of that. If it was erroneous 20 years ago and was never changed, it continues to be erroneous.
Because my understanding is that the claim is to challenge the current term, not the prior terms, right?
That's correct.
It's the current term. So the question that I have is, what evidence is there before the committee that applies to the current term, meaning post this general election, post on November 4, 2014?
Well, actually, the qualification for this term under the Constitution starts the time that the nomination papers are filed. The qualification for somebody to hold office in this term starts the date of the nomination papers and is a continuing qualification. And so the petitioner's argument is at that time, Mr. Say did not have legal residency and continued not to have legal residency. And so there doesn't need to be some new act that needs to be demonstrated after January 21st to prove that if all of the relevant evidence occurred before opening day last month.
Okay, so if we assume it's correct that we can consider evidence that applies to the period after the nomination papers were filed, then I see that there's at least 2 pieces of evidence that fall within that time frame, and those are the declarations that were submitted by Ms. Bonk and Ms. Hussey, and those are dated, I believe, September 8, 2014.
Yes.
Okay. Thank you very much.
Members, any other questions? Okay, I have a couple here. Let's see. So with regard, as you know, there's been several previous challenges to Speaker Emeritus Say's not exactly in the way that this challenge has been brought, but having to do with his qualification to vote in the district. And the fact pattern from the information that you provided and we've discovered on our own seems to be that the information required for each of these challenges is quite similar. And as you know, all the previous challenges have been rejected by the appropriate authorities. Why do you think there's let me ask 2 questions. One, is there some qualitative difference between this particular proceeding and the previous ones that would make a finding or ruling in your case more likely than in the other ones?
Well, first of all, the city clerk and on appeal, the Board of Voter Registration doesn't have authority to determine doesn't have jurisdiction to determine whether someone is qualified to serve in this House or whether they legally possess the title to office. Petitioners' position has been that that's for the courts and the House. And in Hussey versus, say, the Intermediate Court of Appeals agreed with the petitioners that, in fact, the city clerk has no jurisdiction over the qualifications of somebody possessing the office of legislator. So,
go ahead.
Oh, yeah. So, in that respect, that is a difference. The object of the inquiry of the city clerk is to determine whether or not Mr. Say is registered in the appropriate precinct. That's if you read through the voter registration part of Chapter 11, that's the duty of the city clerk, only to determine that. And of course, the legal conclusions that the city clerk makes is not binding on anybody other than the city clerk and the Office of Elections for purposes of voter registration. It does, I can't cite at the moment the section HRS, but the city clerk, if a court or another body makes a determination about residency, the city clerk is to transfer the registration to the proper precinct. And so even the statute itself contemplates that the clerk's decision is not absolute, and it certainly is not binding on this committee in any way. It wasn't binding on the courts in Hussey versus.
Yeah, I don't think I disagree with obviously we're the legislature. We're not the ones who have the final say on what the law means or what the Constitution means. That's reserved to the courts. But it appears to me that I don't disagree that this is a unique. This is a different legal question than the ones that have been answered before. This is a different legal question than the ones that have been answered before. But from a factual standpoint, it seems to me like they're very closely related. And I'm trying to figure out why, or if you believe that there's any reason that your case is stronger somehow because you're here at the House as opposed to the clerk's office or the appeals board from the clerk. It's pretty much the same facts that we're talking about, correct?
I'm sorry, you're asking if we believe that the case is stronger because it's here as opposed to the city clerk's
yes,
office?
Essentially.
Well, clerks do get it wrong. In the case of Dupree versus Hiraga, the Maui County clerk found that Salko Halahala was a resident of Lanai, was born and raised on Lanai, lived on Lanai almost his whole life, represented Lanai in this House in the previous session, and represented Lanai on the Maui County Council, and the clerk found that he was properly registered on the precinct of Lanai, and the Board of Voter Registration felt otherwise, and that was upheld by the Hawaii Supreme Court. So I don't think there's any cursory, non-adversarial decision made by the city clerk regarding the where someone's voter registration is properly put in terms of its precinct is not the same as if the court were to make a determination, or if this House, partly because the stakes for the city clerk, in the case of Honolulu, or the county clerks in the other islands, the making an error, the consequences of that are quite small to the city clerk. If an error is made, the statute provides other ways for there to be a correction. But if this House errs, the consequences are much more substantial. And so the petitioners believe, and as we said in our summation, that this committee must do its due diligence and discharge its duty to investigate as contemplated by Rule 4 in a much more serious and thorough manner than the cursory review that the city clerk and county clerks give to voter registration challenges. And I should note that the 2006 Board of Voter Registration, I believe the decision was 2-1. It was certified and signed by all three, but my understanding was that it was a 2-1 decision.
Representative Say touched on it quite a bit, but I know at the risk of being repetitious, do you believe there's new evidence that has come about, not so much since the beginning of Speaker Emeritus' current term, but since the last challenge to his qualifications failed. Is there anything new in terms of what the evidence would be?
Sorry. In terms of available evidence from the the declarations of Ramona Hussey and Keiko Bonk, there's a lot of new evidence in that respect. The admissions by the Speaker of the House. Ms. Hussey did on a regular basis go by the house at 1822 10th Avenue. That's all new evidence, and of course, every day that Mr. Say doesn't live at his house is new evidence that he continues not to live at the house on 10th Avenue.
I guess I didn't ask my question precisely enough. But in terms of, that's the essential argument that you're making, is that he doesn't live there where he's claiming to live. But is there actually any new documentary evidence or new eyewitness accounts that would indicate that anything has changed from 5 or 7, 8 years ago when this saga began?
Well, I think that's Mr. Say's position. But of course, again, the evidence that is new from 2006 or 2010 is the information that was provided in the declarations late last year by Ms. Hussey and Ms. Bonk. That is new information. But obviously, if someone is absent, a change in that situation would mean that he possibly does live there as opposed to doesn't live there. And so we're not aware of any evidence that that's changed. In the last 5 years, he still doesn't live at his house.
Okay, that's fine, except that the previous challenges failed, and so if it's the same as it used to be and those failed, then why wouldn't this challenge fail as well?
Well, for one, as I said, the investigation by the city clerk, the stakes are much smaller, and the investigation is not in any way adversarial. The city clerk doesn't expend any kind of effort when they review this. And so, I'm not exactly sure, if the House feels like it's bound by the determinations of the city clerk and the Board of Voter Registration.
No, I concede that point. This is a separate proceeding, in my understanding from the documents you presented and your opponents have presented as well. That this is a separate legal question. I'm not arguing about that. So okay,
members, I don't want to hog it entirely. Anybody else have any questions?
Representative Evans, go ahead.
Everyone, I'm not a lawyer, so bear with me. I keep looking at this residency requirement, and it says pursuant to Hawaii Revised Statute 11-13, subsection 1, for election purposes, the residence of a person is that place in which the person's habitation is fixed, and to which, whenever the person is absent, the person has the intention to return. So from what I'm gathering is, he always had intention to return. So I don't know how you, through your argument, can come to some conclusion as to what his intention was. So from my legal, I'm not legal. So how do you make the argument for intention?
Well, when I represented Mr. Kohohalahala before the county clerk and the Board of Voter Registration, he made the exact same argument. And the Hawaii Supreme Court said that intention, you can't, well, as I quoted about the person coming from Los Angeles and then going back to Los Angeles, you can't do some de minimis act to fix your habitation somewhere and then just claim that you have an intention to be there. It renders the physical presence requirement of residency an absurdity if you do that. And so, I guess one question is if you do believe that Mr. Say ever actually did live at his 1822 10th Avenue house, then you have to determine at what point does someone not living there, does it go from being temporary to permanent? The honorable evidence from before this term. So the question is, when does something go from being temporary to permanent? Is it one term of the legislature? Is it 2? Is it 10? Is it 20? How many terms of a legislature does someone live somewhere else before they're considered not to live there anymore? And I think that the Dupree versus Hiraga case makes it very clear that the Supreme Court believes that the law does not allow someone to live in one place and claim residency somewhere else simply by having some unprovable subjective belief that that other place is their home. I mean, the home is in the heart, but for legal purposes, you can have only one legal domicile.
Again, I have to get back to this intention thing because, you know, I just know from my own personal experience that sometimes you have a home, but you kind of like being at the other place. But, you know, so, I mean, you're hanging out at the other place for personal reasons, whatever they may be. But you're still, that's your home. Be hanging out with my home. That's where, you know, that's where everything's at. It just happens to be I like to hang out at the other place. And so, but the thing was, is it still was my home. It was my intention to be my home. It's just, I had reasons. So I'm just struggling with how you come to that conclusion that the intention was that this wasn't his home. Just because he's wanting to go over and spend time at the other house. And it seems to me so you're, I don't know why I just can't figure out how you're getting to.
The statement before the question was that, well, you keep your things at one place, but even though you're somewhere else. And I think other than the photo shoot with Bob Jones a few years ago, I don't think there's any evidence that there are any things of Mr. Say's that have been in that house for decades. And so there's been no evidence. The only evidence has been an intention to return to that place. And, you know, there's no criticism about spend a lot of time in the Philippines each year, but I didn't think that by doing that made me a resident of the Philippines. I still considered Hawaii to be my home, but of course I didn't take all of my things with me when I went to stay with her and take care of her. So I think that that's one of the differences between what you're saying and the situation that's before you, is that that's what the distinction is of that is when you set up your life somewhere outside of your district.
Thank you. Any other questions? Well, I'll go ahead and continue for a little while longer, and we'll see if anybody else has anything. So, I mean, the question you asked about, or the point you make about when does the intention to come back eventually become? Do you have any cases or any statute or anything that says what that judgment call would be? Because I think it's pretty clear that it is a judgment call. I mean, if you accept that line of reasoning, that there's a judgment call to be made. It says, it's 2 years, or it's 8 years, or it's 3 weeks, or whatever. Do you have any opinion on that?
Well, I think the only case that's directly on point or close to being on point is the Dupree versus Hiraga case. No, it sets out the two extremes. Yeah, okay. So not very helpful. And there is a tremendous amount of case law about the issue of legal domicile, because of course that always plays into when people die and there's something left for family members to, or when people get divorced and live in different places. Those are usually the two big areas that legal domicile has been chewed on by courts.
With regard to precedent and maybe more specific to a case like this, there's also a lot of cases on other states where challenges have been made to members' qualifications. And from what I can tell, virtually all of them have been decided in favor of the sitting member. Is that incorrect?
Are you, with respect to members of state legislatures or office holders in general?
Well, members of state legislatures was the ones that I've seen, but I didn't know, if you have other information.
Well, I know recently there was a state senator in California that lived in one district but claimed that he lived in another, and he just went to jail. And I don't think that he's still sitting in the state senate. But I didn't check that out. It was just what I read in the newspaper. So it's quite possible that 200 years ago there was a presumption in terms of an office holder being legitimately in office, but I'm not sure if that continues.
Unfortunately, I can't remember. I've read a lot of legal documents and a long string of two-line entries saying Iowa decides 25-45 to retain a member in the legislature after his qualifications were challenged, and then there's just state after state after state, and I don't remember a single one where the sitting legislature actually kicked anybody out.
If that was the string cites from Hussey, or was it a different case?
It might have been. It seemed like it was the ICA, but I don't know. We'll come back to that.
Sure. Well, I think just to let you know, Hawaii in one way is exceptional from other states because Hawaii is the only state that allows courts to get involved in. The other state has adopted every other court, Supreme Court, and every other state has adopted the position that courts have no role in that whatsoever. And so I'm sure if there are actually court cases that got to the merits of a case saying that somebody was in fact qualified to be in office, or if it wasn't more summary saying that the courts didn't have jurisdiction over it, and that was something for the House. In terms of the precedence of the U.S. House of Representatives to hear these kinds of challenges, and there's quite a few over the last 200 years, I think that a majority of them sustained the person who had presented their certificate of election being to be seated as a full member, but it certainly wasn't all, and quite a few of them did have a partisan overtone to them. And I think I've read some studies where people have gone through and tried to make claims about something correlates with something else, but it is a majority, but not all, and not a huge majority.
I think you're correct that the strengths I recall was one that said many of them said it's not our decision to make, but then they mentioned what the actual decision was too, and which was we're going to keep the person, and they weren't disqualified.
All right, I'll stop again. Any other members wish
to speak? Okay. One other question I had then was about. I think you said in your presentation that you thought that it was possible that Mr. Say the Representative Say had never lived in the 10th Avenue house.
Well,
that seemed like a change from what I'd read in the petition. And
well, the petition for a quo warranto, or the petition to the
petition to the House.
That point wasn't specified, partly because there's no evidence.
From all the way back, from the date that he purchased it, you mean?
So, for an example, in the declaration of Mr. Say that was submitted on Tuesday, he says that he bought his house on 10th Avenue in 1980. But from what was recorded in the Bureau of Conveyances was until 1983, and the directory of how Hawaii state officials has his official residence as his childhood home in 1981. So I think there's this part of what happened in the early 80s, there's a question, and unfortunately because my clients have never been given the opportunity to obtain discovery, we have not been able to gather evidence to make a determination about whether he actually did establish under the general accepted legal requirements about whether he actually did ever live in the 1822.
Okay, that's the point. So I mean, that's the question I had was, so your position, the petitioner's position is now that he never lived in that house.
Well, it's their position has never been that he's lived in the house, but based on the evidence that was available through today, it is not clear whether he's ever lived in the house.
All right.
Hopefully you guys can use your powers to investigate.
One other question in this regards. About a third of the legislature are from the neighbor islands, and during when we're in session, for about the 4 months that we're in session, they spend probably a lot more time here on Oahu than they do at home. How do you differentiate those two situations where a neighbor island person? I mean, well, I guess the more important question from my perspective is, what couldn't, if we were to find that Speaker Say, there was compelling evidence that former Speaker Say didn't live, that he should be disqualified, wouldn't there be a whole bunch of other challenges, especially to neighbor islanders who aren't here a lot of the time, and you can drive by their house and say, Representative Evans, she's not there. Where is she? What's going on? Does she really live here anymore? So how do you differentiate or distinguish those?
Well, two things. First is the Hawaii State Constitution provides that when someone is in the service of the state or is attending an institution of higher education, that they do not lose their legal residency because of that. All of the evidence that's been submitted by the petitioners all involve observations of Mr. Say not living in the house at 1822 10th Avenue when the legislature is not in session. And so it's not an issue of trying to be clever and keeping a log of maybe he's sleeping in his office during session. This evidence occurs when he's not in session. And so I can't speak to the more general claims, at least the possibility that someone might make that kind of specious argument about neighbor island legislators. But, if somebody who represents a neighbor island district does in fact live in Honolulu, that is different than a neighbor island legislator who has to be in Honolulu for 4 months out of the year because he's a legislator. And, that's something that a House special committee would have to look at on a case-by-case basis because they're all very fact-intensive cases.
Okay, thank you. Members, any other questions? If not, let's take just a short recess, and we'll have the presentation from Speaker Emeritus Say. A short recess.